Hi, it's Grant Abbott speaking. I'm here with Michael Jeffriess and also Rod from Eventum Optimum. How are you going, gentlemen?
Good, thanks, Graham. How are you doing?
Yeah,
Hi,
yeah,
Grant. How are you?
yeah, good, thank you. Look, I don't want to steal any of your thunder. I just thought I'd go through a quick update for the guys. We're getting huge amounts of the protector going through. People charging between $4,000 to $6,000 for this strategy. It's a great strategy. Some of you may have seen it coming up or being marketed to your clients as the Vesti Trust. From that perspective, people are charging $8,000 to $10,000 for that. I think it's DPI who are doing that, and they're paying commission to planners on that one. That's what I heard anyway. So obviously, it's a much better solution for you, as is all of our LightYear Docs. We make sure that there's plenty of in it there for you, and we've got some fantastic new asset protection mechanisms coming up early in the new year. So it's going to be very exciting. And Michael, myself, and Tim Munro are writing a book on succession asset protection and estate planning. So there's a lot going on, and love to get all of you involved in SEPEPA, which is the association. We'll be having a meeting on that in the next couple of weeks. So watch your emails for that one. Anyway, let's have a look with the protector. Obviously, the purpose of the protector is to, I find it from an estate planning perspective, of a huge use rather than build testamentary trusts, wills, etc. It's a lot quicker, honestly, to build the protector. And obviously, if there's no assets in the estate, and they're in the family protection trust, then essentially where we're going with that is that that protects us from family provisions claims, which really can really decimate an estate. So I love using the protector. Sometimes I'll just go down. I'll still build a will and testamentary trust for clients. But then as soon as you find out that they've got a former spouse, they've got obviously an estranged child, then that's when you move to the protector. Likewise, from a family law perspective, it's not guaranteed, but if you've got a good chain of succession, making sure your client is not a trustee of that particular trust, it's a great little strategy for family law. And even if we're finding a lot of our accountants and advisors are using it for clients who are going into their second or third marriage. So they have all the trimmings, all the bells and all the whistles, all the playthings, but at the end of the day, they have nothing in their books. And each and every day, we're building, better systems, better tractions for that, and that's certainly where Rod and Michael will be talking about very shortly, and of course into the new style of employee share plans. Again, one of the special things about the Family Protection Trust is that it's only for lineage and direct descendants. Again, you'll find most of our stuff, all our key leading member documents really are built for that bloodline, which I think is absolutely crucial. If you don't want that bloodline, if the client doesn't want bloodline protection, then you can just use a straight out discretionary trustee, which is certainly not my thing. So on the legal side, I won't go through. I'll send you these slides anyway. But Pelly and Nolan dealt with a gift versus a loan in terms of family law, which was absolutely crucial. Tia Nussbaum looked at the protector and essentially a gift and loan back strategy. Unfortunately, the client did it to their mother, and then the mother had a bit of a fight with them and didn't wanted to enforce the loan. Lucky there was a registered mortgage there, and ended up Tia lost the case to Nussbaum. So that's the classic one. And traditionally, it was just came down to what were the documents, what did the documents say, particularly where you've got a couple of warring parties. The judge really didn't think that either of them had a lot of truth between them. So it came down to the documents, the parties, and also the registration of the mortgage, which we'll talk about shortly. For bankruptcy, really doesn't, you can't just, if you've got a client now who's on the verge of bankruptcy, the protector's not going to work because you'll have the clawback. But certainly if you've got a client now who's who's in a position, a reasonably solvent position, it's a great idea to do it now. The protector works just like this. So we might have a home, cars, Bitcoin, We've got net equity there of 1.1 million. So we take out off our liabilities. You'll find on our strategy center, we've got a letter or an email you can send out to clients on the protector. And that includes the data capture being what's your net equity. This is obviously the strategy is to settle or gift that amount into the Family Protection Trust. It's $1.1 million would be gifted in. It's only for family beneficiaries, lineage or bloodline. And then that's lent back to the family for utilisation in their day-to-day life. The beautiful thing I like about it from a tax perspective, because obviously we're not going to be paying much interest on that loan. The beautiful thing that I like about it is we're not transferring the assets. So traditionally, I dealt with one yesterday. It was a client who had their family home, and obviously that's still useful for the perspective of ensuring that you get the principal place of residence exemption. And then secondly, they had 2 investment properties, which were highly negatively geared. So again, that was a great strategy to keep those assets there, get those tax relief outside of any trust, but knowing that the equity is sitting in. So it's actually the best of all worlds from my perspective. It's probably even better than having those assets inside the trust in first instance. Surely it would be better from an asset protection, but if you've got losses locked up in a trust, it doesn't really help anyone. So that's the protector. I'll just bounce out of there. And then I've got one here to show you just briefly. I'm sure most of you have already seen the protector. This is one I did a while ago. You can see on October the 30th. I'll just relaunch that. This was sitting in my vault. So this is Ken and Ken Rose, the butcher. So he and his wife. So I've got the Rose butcher. Common parties we put there. In fact, I've got, sorry about this, so we'll just put Julia Butcher there. And then we've got the Family Protection Company, which we've already set up a while ago as well. Now, what we can do is if we think it's a joint asset, we can just simply add another. So I might put in here, Ken Butcher, select the address. This is a new feature of ours. So you can now select the address really quickly. And so that's gradually being wound out to all of our stuff. So the documents, do you want to establish a trust? We'll go no, because we've already got a family protection trust. But if you wanted to, you can actually set up a company and also a family protection trust. With this one, you need to obviously go externally to our LightYear Docs site and set up a leading member, or in fact, we've got a new one coming out next week, which is our family protection trustee company. But the documents we're having is a solvency certificate, deed of gift, promissory note, loan agreement, mortgage deed, and personal guarantee. So all of those documents are produced pretty quick time as we go down the track. Obviously, we've got the discretionary trust, so on and so forth. So you've seen that plenty of times previously, but you know, again, it's one of my favorites there. Good to see Tim on there as well. I need to make sure that you are on all our sessions, but it's great to have you on, Tim, and really looking forward to catching up with your session tomorrow. You had huge amounts of value. Anyway, I won't go further into the protector, but one of the key aspects here is obviously when we get down, I'll just show you the package of documents that it sets up. And honestly, it takes no more than 25 minutes to complete. The big issue is at the end is going to be registering a mortgage and also PPSR over, for example, the cars, jewelry, furniture, etc., which the guys will have a look at very shortly. So I'll just show you here, we've got the protector, build that up. This is for the Rose Butcher. These are all the documents that are produced, the Family Protection Trust Deed, Solvency Certificate, and all of those as well. So just want to go down to the end and have a look at here. We've got the mortgage deed between the various parties. And also that's produced because the mortgage is in, or the property's in Queensland. We also produce a Queensland certificate for registration of that mortgage. Understand now that Queensland has just been logged into PEXA, so you can now do everything electronically. And we certainly through, I think Michael and also Rob will be talking about that as well, lodging that mortgage and also PPSR, because that's, if you have a look at that, a tyre versus endorsed bond, that's exactly what's required. Anyway, what I'll do is I'll hand over the reins to Michael, and I'll get him to have a go at there. So you're now the host, Michael.
I'm going to share my screen. Hi everyone, as Grant mentioned, I'm going to just run through a PPS service offering we've got for LightYear Doc members today. I'll just give a brief overview of the PPSR legislation. I'm sure everyone's aware of it, but just for anyone who watches this video at a later time, or anyone who's not aware of all the intricacies of it, it'll give you a bit further detail. Then we'll go through one of the famous cases where they got the PPSR registration actually wrong, and why it's important to ensure that it is done correctly and it is the right assets are secured, the right entities are secured, and the right type of PPSR registration is taken out each time, because it differs depending on what entity it is, whether it's individuals involved as well, what you are securing, whether it's goods and services, and how you're actually securing it. But more importantly, as Grant always says all along, one of the big keys is ensuring you have the right documentation in place and what you're actually protecting. So PPSR, what is it? PPSR is the Personal Property Securities Register. In effect, it's an official government register, which is and it manages the Register of Personal Property Securities. It commenced in January 2012 via what was introduced at the time, a Commonwealth Personal Property Securities Act 2009. And there were a number of state and Commonwealth legislation, that act in particular, but in January 2012, there was an amendment that introduced the Personal Property Securities Register for the whole country. Prior to 2012, what was the position? Ownership was king, but unfortunately it wasn't always easy to prove ownership. Obviously you may have legal title, but if you didn't have title or recognition of such, then there wasn't anything, a register or anywhere we could see who actually owned it or had security of ownership over that good or service. The PPS Act led to the creation, as I mentioned before, of a single national online PPS register. Any holder of a security interest in a personal property must register, or they should register, to ensure they have a priority claim to that property. Legal title is simply not enough anymore. You need to secure your interest. As a buyer, you can search the PPSR to see if goods are debt-free. So if you're buying second-hand goods, say a second-hand motor vehicle, you can go on there to check and ensure whether it's unencumbered and then safe from being repossessed if you do purchase. Well, we all know the stories where a friend has bought a second-hand car from someone. They find out a couple of months later it may be stolen, or it may have debt owing on it, and then they become liable for that position because they now have taken possession of such goods. Businesses should always consider including in their terms of trade. Every client we deal with, we ensure that we work with them in updating their terms of trade to include it. We work with a number of accounting firms and advisory firms, and always even get them to include it. So if you have a creditor that you're concerned about, someone that you provide services to, then as long as it's in your terms of trade and as long as you do it in the correct time manner, then you can register that invoice on the PPSR and take security over it. So, and I've found it's actually been a good way to actually collect fees of clients that you may be concerned of, where there may be potentially an insolvency event, then secures your position as well. So it's extremely important that you consider that. So businesses can register debts that customers owe them, which I'm saying there, by registering interest in those services as goods that a business has not received payment. Great protection around insolvency.
So Michael, just quickly on that, the other area which we use is we put charging clauses. So that essentially is our clients can lodge caveats and other charging clauses against personal property of directors and owners of businesses. So that acts obviously as a big ensuring that the clients receive, they get us to make payment to them. So a charging clause along with a PPSR security interest clause in those terms of conditions, the chance of your client getting paid or being protected for payment increases exponentially.
That's correct, Rod. Good point on that. And another big area, which I'll get some feedback from Rod here as well, and we see this all the time, because especially, I mean, Rod is heavily involved in the events and Optimum side of the business, and we've got a team based in Newcastle and Melbourne as part of that, and obviously on the Gold Coast. But all of our work is referral work from accountants, advisors, financial planners, and we often see that you'll come across a company or trust where directors or shareholders have lent money, often at the start, to start the company, to fund it for working capital purposes, and they will provide funds into the business by way of a loan that has not been secured. So, and that includes trusts where you'll see loans to beneficiaries, so unpaid present entitlements, and they're unsecured. And one of the first things we do is, obviously there's some time factors which we'll go through shortly, but we make a move to secure those. If you want to just discuss that a little bit as well, Rod.
Yeah, well, that's a really good example, because when businesses start up, obviously cash is poor. They're trying to get the business running and operational as quickly as they can, but protecting their own contributions is often overlooked, and it needs to be done in a couple of ways. First of all, it's got to be done within the time frame, which we'll talk about, or we're talking about now, I see, we're about to come on to, but also it needs to be documented, and it needs to be secured. So an example we had last week of a client, it was a construction business, unfortunately, which had to go into administration. The sole director of the company took a loan from his girlfriend and from his sister within the last 6 weeks before the date of insolvency, and because those amounts weren't secured at the time, those amounts now rank as unsecured payments and preference payments. And even though that was a loan which a company borrowed for a couple of weeks to meet contractors' payments and supply payments and was repaid immediately, that was deemed a preference payment under the eyes of the administrator, the insolvency practitioner. And it was done with good intent. There was no intention to, the money was provided to just help the company through a cash flow issue. But because the I's weren't dotted and the T's weren't crossed, these two, the girlfriend and the sister, now rank as unsecured creditors and are at the back of the queue for priority of payment. And will, from looking at the financial statements of the company, will probably get nothing back. Even a simple document and a PPSR lodgement would have meant they would have got paid straight away, and any insolvency practitioner had no claim on those. But at the front end, Michael, that's 100% correct. So when you set up a new company or a company's in financial difficulty and needs to get assistance from the owner, external monies, at that point in time, we need to put in place a loan and security agreement, which we can do for you or for your client. We then need to make sure the security interest is lodged under the PPSR regime, and the actual transactions actually obviously take place. So we put that in place for your client. It works similar to a Division 7A loan, so we can put one in place. So it's a revolving facility, so you don't need to, once you provide funds into the company, you don't need to do a PPSR security interest each and every occasion, just in the first occasion. But then it becomes a secured creditor, and if your company gets sued, your client's company gets sued, financial difficulties, whatever it might be, you rank above, as an example, the ATO. The ATO in almost all instances are unsecured creditors, and your client will receive their repayment first before any other creditors, other than, of course, the almighty liquidators' fees. So it's a little a cheap and easy strategy. And Michael will talk about the timeframes just in a second. But if we miss those timeframes, you'll put your client at risk, first of all, over an extended period, but potentially forever. And those clients might receive none of their monies back, when a simple procedure would have, protected them a lot better. We've
been able to have positions where the client's got money, as you said, because they're a secured creditor ahead of the Australian Taxation Office and other unsecured creditors, haven't we, Rod?
Absolutely. It's just, and we can structure it prior to any event if we try and avoid it at all instances. But the cheapest and best way and the most effective way of doing this is at the time of the provision of this financial service or the money's been provided. And I guess if we could just get into, if with our clients we get into a habit of actually doing this, then the client's always protected. I know we never look at the glass half empty, but for a relatively cheap cheap mechanism, we have your clients fully protected and secured against any unforeseen events. The other thing about that as well, it also acts as a deterrent. So if a creditor is going to be taking action against the company and they go and look at the PPSR searches and they notice that there's a lot of security interest already lodged against that company, that might stop them. They might start to come back to the table to negotiate with your client a settlement, as opposed to taking any further action, because they can see that they rank a lot lower in the priority scale. So it's not just protecting their monies, but also acts as a defence mechanism and a deterrent, against predators and creditors, as Michael will refer to a bit later on in this speech.
Thanks, Rod. I can see we've got a couple of questions already. We'll answer them towards the end, but we'll just keep going. As Rod, this is a particular slide in relation to the business loans and the UPS we're talking about. It's paramount that you have the necessary loan and security agreements in place that meet the requirements of being able to register on the PPSR. So they must have the right clauses and information in there that reflect the PPSR legislation. So the business owner, as we said, becomes credited. Now we get to the timing. So it needs to be within 20 business days of the provision of the service or the funding or the finance. So if not, it remains green, as we like to call it, and it can be classified as an unsecured creditor for a term of at least 6 months. Now, this is not the relation back period, which I often talk about around liquidation period. This is in terms of the PPSR. So if you don't get that timing right, then you're at risk for that 6 month period until you can be absolutely unsecured.
And on that, I mean, that's a general rule, and that's a rule we should observe. But particularly with directors' loans and other loans, we do have a couple of strategies and tools we can put in place with funding. So if you've got a client, for an argument, who's provided funding to the client, a loan to the company, so it's a liability loan to the company, and you're 3 months in, you should lodge that security interest and documentation now, as a matter of course. But if there are some distress signals, such as landlords, financiers, creditors, etc., ATO coming after your client, we do have a couple of strategies up our sleeve which we can work towards this. But generally, as a rule, if you lodge within 20 business days, you're 100% covered.
Yep. So we'll just go into, I'll just give a couple of dot points and let Rod talk a bit more in relation to the detail of it. But what happens if you do get it wrong? And one of the famous cases from 2016 was Forge Group Power in liquidation versus General Electric International, so the big GE. So GE lost its interest in a turbine. So this cost was worth $60 million because of its failure. So it lost its ownership interest of a $60 million asset because of its failure to register its interest on the PPSR correctly in what was held to be a PPS lease. While the bank had taken a registered security interest over the leasing company, neither the bank nor the leasing company held a registered security over the insolvent company. You want to just give a quick rundown of that, Rod?
Sure. So this was deemed, the term they use under PPSR is an unperfected security. So in this instance, General Electric was deemed to be in the business of leasing equipment, but because they hadn't officially registered on the PPSR security register, that was overturned, and the assets, those $60 million of turbines, actually went into the pool of assets for the liquidator. So the company went to administration first and into liquidation subsequently, and those assets were then disseminated in priority to other secured creditors before GE. So in this instance, if GE hadn't followed through what we were referring to earlier and put in place that security interest, there was no way that the courts could have overturned this decision, and those turbines would have immediately been obtained or recouped by GE. So the reason it's obviously so big is because it's quite clear, this case, about the necessity to actually register. So a lot of people in the old fixed and floating charge regime, and beforehand you could call it entitled that you had a charge, but now this makes it very clear that unless you register that charge on the official PPSR register, you're at grave risk of losing those assets And in liquidation, as you're probably aware, when a liquidator comes in, they take and seize all assets they possibly can. They do the searches on the register, and anything that's not on that register is open slather as assets to be disseminated amongst that estate. So it is such an important thing to put in place. So this was a really clear case of what there is. Look, I guess it's probably a good time also just to talk. There are two types of security interest, and I briefly touched on the fixed and floating charges, which was the old regime, and people of my age bracket know about that link, so it's a good way to explain. So the old fixed charge is now what's called a PMSI security interest, a PMSI security interest. And that stands for purchase mortgage security interest, and that's over a specific asset, and it's got super priority. So in argument's sake, if you issue, in this case, a turbine, it's a physical asset which can be identified. You take a PMSI security interest across that. In the event of any recalcitrant payments, insolvency event, dispute, the provider of that equipment or financier of that equipment has the legal right to go in, obviously sufficient notice, go in and reclaim that asset, and it can't be taken by any other party. So it's the strongest security interest you can possibly have because it's over a specific asset. It's very, very clear. It doesn't work on a couple of things like, example, roofing equipment, which it's very hard to identify. So it needs to be quite clear in your description. And we've seen, the reason I said roofing is we've had a client previously who had hundreds and hundreds of thousands with a scaffold. The security interest which was lodged said all roofing equipment. It was far too vague, and as such, there was no register put up with it. So when they tried to reclaim those assets, they were unable to do so. In actual fact, they lost their asset. So the PMSI needs to be identifiable, but also have a specific asset. The other type of security interest is what's called all-PAP. Unpleasant name, or all present and after acquired property. Now, what this refers to is like the floating charge over a company. So when a bank might lend an overdraft facility or you provide a loan to the company, you've got a claim to all assets of the company. So in the event of an insolvency event or some kind of claim, you get first rank of whatever assets are sold other than those specific PMSI identified assets. So you get rights to all assets of the company. So it's important to get these right. With the PMSI, there is a thing called a super charge. I know it's a strange term, but if you lodge within 15 days of PMSI security interest, it can never, ever be overturned. So if you've got a specific asset, 15 days is probably a more important date, but 20 days recovers you from you can't be regarded as an unsecured creditor. So this case, this GE case, it's used as precedent throughout the PPSR of the importance to register within the relevant time frame, which is 20 business days before you provide these services. And if a company like GE can lose $60 million, it just shows you how careful and how important this is.
Thanks, Rod. So we've got a PPSR solution which we've been working with a number of LightYear Doc members for some time now, but we haven't taken it out to the broader audience, which we're just discussing today. So we will, in LightYear Docs 2.0, effectively have a button which we're working on doing for Tim Munro and Change GPS, which will provide an API link and a link into Change GPS and also Abbott Mourly, but we'll also have a automated solution that will be when you need to register a document or in PPSR, you'll be able to press it and it'll flick everything through to our team at EO to deal with it. But at the moment, effectively, the accountant or advisor contacts EO via email, call, we'll have a discussion. They provide full details in relation to the client and the documents and the funds transfer where that is applicable. So depending on what we're actually looking at registering or reviewing, we'll review it, prepare the relevant documentation where applicable, if any additional security agreements are required, and then we'll lodge the appropriate security interests on the PPSR, and then we'll provide those PPSR tokens, references, and the details back to the accountant in relation to their client or accountant advisor, I should say. So in terms of pricing, this is quite competitive. There are a number of external providers in the market. They're charging 550 plus. Some I've seen up to 900 which includes a loan and security agreement. In relation to the protector, where we've got mortgage documents and a loan agreement, then it will only be a PPSR registration. But in the terms of where you've got business, director, shareholder loans and UPSEs, we have to ensure that we have the right loan security agreement in place, and we'll register that for a 7-year period for $275, including GST. If there are additional PPSRs required for the same entity over different assets, then there'll be a reduced fee of 110. Once again, significantly lower than external competitors. This is for LightYear Doc members only. And then for PPSR registration process only, it's $110, including GST. For other mortgage registrations, so in relation to registering a mortgage, discharging a mortgage, or any other changes in relation to mortgages, then it's $330. This doesn't include any external legal costs, which may require the preparation of any mortgage documents. Obviously, the protector has a mortgage document in it. If and when we do require that, we always refer that in the first instance to Abbott Mourly, so to Grant and Tony in particular, and they will prepare those documents, and they'll obviously provide a price in relation to that, which will be very competitive. Just some other services I thought we'd run through. We've talked about this before in relation to EO. So EO is a pre-insolvency business turnaround asset protection consultancy business. It's focused on those insolvency or pre-insolvency issues. We also work in, I've done a large number of capital raisings for clients. We're going through one at the moment, and we've got a number of funding and working capital solutions we can provide to clients, to your clients. We do a number of obviously creditor and what I often term creditor negotiations. So we've secured and unsecured creditors. That can be landlords, ATO, although ATO often will only move in relation to the time of payment terms, and they may reduce a bit of interest, but we can often get payment terms out longer than 2 years. I've managed to get 5-year payment terms with the ATO. We also deal with other creditors such as funders such as Go Capital, Funder, etc. Obviously, liquidation. Whilst we try and do what we can to avoid liquidation, often there may be positions where we have to enter into liquidation. So we'll manage the appointment and consult with you and provide a panel of external providers that we utilise. We also have a number of management consultancy services around CFO which provide into our accountants and planners. So we've got a bit of a point of difference compared to other pre-insolvency firms. I think of it a bit like the conveyor belt, which I often talk about, Rod. I think people go in, they help the accountants or advisors clients. Sometimes we get direct clients, we help them, the pre-insolvency business turnaround, and then they fall off and then they move on to the next one. And they don't go and look at, okay, in 3 months' time, 6 months' time, 12 months, now that we've helped them, we've turned things around, where are they at? And we work with the accountant and advisor, with their client, and that may involve a report on the page, and it might just be a half an hour Zoom, and we'll look at where they're at, where they're headed, make sure there's no other problems starting to appear, so that everyone's heading in the right direction. Obviously, we could just let them fall off the cliff face again and then charge them a fee to help them try and turn around again, but we don't want to see that. We actually want to see them headed in the right direction. So I'll just let Rod have a quick chat about that as well.
Yeah, thanks, Michael. That's a really good point, because we aren't insolvency practitioners ourselves, we're not conflicted, and there's no, if the solution is to avoid insolvency, we'll always do that. And quite often getting in early and using some of our negotiation and structuring and protective measures in themselves, they prevent that event occurring. And look, it's interesting because the government, and I'm sure we've all seen, there's some new legislation in foot at the moment, and the government, in recognition that we have had obviously a tough times with COVID, they're looking to amend the insolvency laws. Essentially what they're doing is they're pushing away from liquidation and more to the administration side of things. So it's along the US law type of things. So it's recognising two things. Number one, that the cost of liquidation is quite expensive. So when you do involve the liquidator, the costs and the effect is quite hard. So what they're looking to do is they're looking to empower the directors of a company to be able to make their own decisions, as opposed to appointing a voluntary administrator. And they're looking for solutions, number two, whereby that negotiation process can take place between the company and their creditors to achieve a more desirable outcome for all. So rather than putting a company in liquidation, losing a business, losing employees, and affecting the whole economy, the government is trying to put a solution in place whereby, rather than causing carnage, we find a medium ground here for the businesses to continue. And I think it's a noble gesture. I guess it's interesting to see how it will work in practicalities. But the first reservation is that are these directors sufficiently had sufficient knowledge to be able to make these decisions. I mean, one of my pet hates is that anyone can become a director of a company. They might not know how to run a company provision. They treat it as a personal bank account. They don't protect assets. They act accordingly. So to get them now to make decisions about the future viability of the company is sometimes questionable, but it is good to keep the cost down and keep businesses afloat. I still think there will be a place for the insolvency practitioner and the advisor, but hopefully, on a more on a basis whereby the solution is businesses don't go broke, but they, I guess they have a day of reckoning or a reset, as we've sort of heard, where they can start again. But the important aspect is, as Michael made reference to, there's no good doing this if the underlying viability of their company is not there. So an assessment needs to be made at that point in time. So some of the things that we sort of work through, if we look through those there, of course, is we put protective measures in place, and they might be those loan agreements, those security agreements, might be mortgage documentation, there might be structuring. So asset protection, creditors and predators, includes not just personal assets separating from the business assets, but also the business assets being separated from the trading business. So we put in place hire and rental agreements and asset holding companies. We put security over those asset holding companies. At that point in time, if a company does meet up with some unforeseen instances, and these instances are wide and varied, and in most cases, it's not the directors, they've done nothing wrong, but it could be landlord negotiations, it could be financing negotiations, franchisor negotiations has been a big one of recent years for us. We've acted on behalf of a number of franchisees to get solutions that works for both parties. It could be the ATO, which is more normally done at the accountant level, but we can get involved on the ATO basis as well. A number of cases. I'd like to start with one case study. So we had a furniture company in the Sunshine Coast with a business in North Queensland as well, and how it was structured was we had both partners were directors and shareholders of the company. They had two businesses. One was toxic and one was profitable. Unfortunately, because they were set up under one structure, no protection put in place, one business was dragging down the whole business. So they were recommended initially by their lawyers to go straight to liquidation because the company wasn't making enough money to pay its bills. And if that had happened, the whole businesses would have shut, employees, stock sold, fire sale, etc., etc. Luckily, the accountant made contact with us first, and we went in as a non-conflicted party, and we sat down with the directors of the company. What we ended up doing was negotiating with the landlord of the toxic company, which is costing the business about $18,000 a month. And we found out they actually had other potential tenants there. So we settled for virtually nothing that toxic lease. We moved the stock, we did some evaluations and moved the stock. We formed a new entity and moved the stock into a fresh company. We ended up paying, in this instance, we paid the ATO in full, we paid the trade creditors. There was no insolvency event, there was no parties, but what we were able to do via negotiation was, first of all, split the toxic entity from the profitable entity. And when we then set up two new companies, a trust structure and a new asset holding company. We made one director the risk party, and the other director, we moved the assets, the personal assets, into that individual director's names. So in the end, this company is now trading with it's almost all its staff it had previously. It's very profitable. The directors can sleep at night knowing that their personal assets have been separated from their the business assets, and also the physical assets such as plant and equipment and some vehicles and other fixed assets are put into an asset holding company. And it was a result we were able to achieve without any insolvency event. And the advice that the legal people party provided to this client was to liquidate because they couldn't, they were trading whilst insolvent and go forward. So we were able to do this. What we did do though, this was pre-COVID, so we actually put in a safe harbour defence as well. So if you're not aware what a safe harbour defence is, that's where insolvent trading is both a criminal and a civil case, but with a safe harbour strategy put in place, it protects the directors against civil insolvent trading claims. So you need to meet certain criteria such as lodgements and employee entitlements up to date, etc. You still, and the company essentially has got to be, it's better off trading than going into insolvency. So we put this in place so that the company was able to put these strategies in place first before, sort of like I said, otherwise the company, on the fear of insolvent trading, companies, get liquidated straight away. We certainly didn't want that to be the case. And by having this protection in place, the director was able to achieve a good strategy and a good outcome for all parties. Probably another example is a franchise.
Just coming in there, what's important too, I guess, is that all the referral base that we get into, obviously Rod drives and runs that business with his team in Newcastle and Melbourne, but what's important is from all our work comes from referrals from accountants, planners, brokers, as we've said on the screen, and Rod's talking about restructuring and everything. We always ensure that we refer any of the work back that we can to the accountant, such as setting up new structures if there has to be a company set up or there has to be a new company in trust, and obviously hopefully as you're all LightYear Docs members, you'll be using the great LightYear Docs platform. But we certainly ensure that the client maintains their relationship with the advisor who's referred the work through to us. Well,
that's a good point, because Mike, in this instance, if the client had taken the legal advice, and I'm not having a go at lawyers, it just happened to be this instance, that the company would have been put into insolvency and liquidation straight away. So now the accountant not only retains a fee-paying client, but the client is now in a sustainable position going forward to be a long-term client of that accounting practice. So, and all the valuation work, some accountants do it, some accountants don't do valuation. Of course, we do have a panel of valuers we can actually use.
We're always looking for more valuers, don't we?
Yeah, because obviously valuations are a specified area, and valuation's twofold. It's the business valuation, but also the physical plant equipment. In this instance, there was about $600,000 of stock which needed to be valued as well. So we go through all the legal channels, dotting our I's and crossing our T's to make sure that everything is done above board. But in this instance, all the new company setups, the accounting work, the dealing with the ATO was all done via the company's accountant. So not only did we create some short-term work for the accountant, but we kept a fee-paying a client in place for the accountant, Michael, which is the best solution for all parties. No one, there was a couple of job losses from the Sunshine Coast business, but a couple of their staff were actually relocated to North Queensland to the good business. So it was a great result all around. I guess I might just do one more. Case studies tend to bring up a few cases. On a more extreme example, we've got a franchisee, who's part of a large national franchise. And as we all know, franchises have been a very, very marginal and difficult business of recent times. This fellow had a couple of franchises, and they all started to go pear-shaped, but he had one of his locations was profitable. So in this instance, the personal debt that this client faced was extreme. It was 7 figures. The franchisee was chasing him, but the client had one business which was quite profitable. So what we were able to do in this instance is we were able to go in and review the going concern of the good business. We did some valuations, and we actually put the business for sale and sold it to a third party, and we're able to get a small amount of equity for our client into that business so they could retain some interest in the business. And we actually did a valuation, we did a sale process, and we moved all this around, and we did so with all the relevant security interests, titles, asset structures. So much so that the head financier, which was owed 7 figures, who had a general security or an all-PAP security interest across the company, as well as some personal guarantees, by the time it was all done above board, by the time they tried to exert their claim on the companies had been cleaned up and tidied up. And because we'd done such a tight job with it, the financier, which is one of the 4 majors, entered into negotiations with us at much, much reduced rates, actually 5 cents in the dollar. and were able to make a settlement with that major bank. So there was no personal insolvency event. We did actually, in this instance, we did liquidate the company. There was a little of ATO debt, which was, I guess the word is insurmountable. But by putting these structures in place, it enabled us to negotiate with a major bank, enabled the business to concern. There was about 51 staff in this company, mostly casuals, but about 3 or 4 permanents, and they all retained their work. They transferred employment. They kept their employee entitlements. The business continues to operate. We renegotiated a new lease with the head landlord, and we paid the majority of the creditors in this instance, except for the personal creditors that the director had in place. And we negotiated that with the major bank. And we also used not only those structures, but we also went back and counted on the responsible lending criteria. We were able to argue that the bank had potentially should not have lent money to our client when they might have been insolvent previously. So that was an argument we're able to put in place, and 5 cents on the dollar we're able to settle with the major bank. So again, another good result. There was an insolvency event in that instance, but it was an example of going in non-conflicted. I hope you can see we always try and avoid these insolvencies if we possibly can. So I think probably the key that come out of this is there are so many structures out there. If we can put them in place in the first instance, prevention is far cheaper than trying to solve a solution down the track. So we always would like to put these in place first of all, and make sure your clients are protected and de-risks them against not only these claims, but also as a deterrent against any creditors making action to them. And we can negotiate. Negotiation is probably our key area. We're very good at negotiating, and we do that on 2 folds, either on the fact that client can't make payment, or it's in the best interest of all parties to do this. We can put some protection in place. At the moment, as you're probably aware, up until the 31st of December, insolvent trading is essentially off the table for clients, as is a lot of collection of debts. Come the 1st of January, we've actually put about 4 safe harbours in place in the last week as a result of directors now being aware that come 1st of January, they can be held personally liable for the actions of the company if the company is trading whilst insolvent. So these safe harbour provisions, they're relatively cheap to put in place. And to give a number, they normally cost around about $500 a month to maintain. We do want monthly reports for our clients. So there's a setup cost, but it's not a great deal. And so once you've got this in place, it's an ongoing. It's also good if you've got an angel investor who wants to come and put money into the company. We can secure their money first and foremost, so they're not an unsecured creditor. But also, if they want to come on the board and help with the turnaround, they can do so knowing that they can't be personally liable for any of the advice or the actions that they give to the company. We can also put things in place like we review terms and conditions and charging clauses and structure so that when the client does, not only are they protecting themselves against creditors, but also it gives them best chance of getting their debtors, because one of the biggest areas besides cash flow of a company's insolvency, especially in construction industry as an example, is not getting paid. I mean, everyone puts their margins down to get the business, but at the end of the day, as I say to clients, it's no good getting a contract if you're not going to get paid for it. So if we put personal guarantees in place, we put terms and conditions which have charging clauses and PPSR clauses for that rank first, there's a far greater chance that they will be paid. And we do use some external cash flow solutions, such as not ourselves, but we have parties we can refer to for invoice financing or debtor financing. And the big one is debtor insurance. So you can essentially protect against 90% default against your debtors. It costs roughly 1% of the face value of the invoice. But clients who can't afford $100,000 loss will be happy to pay $1,000 to make sure that they get paid, that they can guarantee payment. Obviously, there's terms and conditions. You've got to make sure that you've got documentation, you follow your procedures and collection procedures, but we can guide clients through that. But debtor insurance to me is one of the strongest tools out there. Not only does debtor finance protect against the cash flow between long slow payments, but also against default. So there are some solutions out there which we can access for our clients. It's probably the sort of the main thing. If you go through a couple of those areas there, probably the bottom ones are key. It's management consulting. By not being insolvency practitioners ourselves, we act non-conflicted. So we give our clients non-conflicted advice. That doesn't mean they have to take it. What we tell them they can do legally and not legally. Sometimes they're on ethical grounds and moral grounds, which we really appreciate. Like we always encourage our clients to pay their employees, especially superannuation and entitlements. we like to see mum and dad creditors paid for, and all creditors paid for, really, to be honest, where we can. But we give the client what they can and can't do under law and what they've got to do. So there's a line not to cross. No asset should be transferred for no consideration. That's just a no-no. We would never let that happen, and everything needs to be documented and valued. So everything is done above board, so that if a regulator or a creditor or an insolvency practitioner tries to make a claim on us in the future, we can just sit there with stand up in a court of law or any instance and say this has been done properly. That's absolutely critical in this case. And if we do have to go down the insolvency path, which sometimes is the case, we will hold the client's hand, and we do have parties whom we deal with, insolvency practitioners we deal with, who we have a fairly good relationship with, where we can, I guess, have a better result for our clients, for the best way to put it. So it's an interesting area, this turnaround and asset protection. We love the asset protection at the early stages, so we can get better results, and we always try and push turnaround subject to the client's viability. And we always sit down with the accountant and ask them and go through the cash flow. Is this business viable if it doesn't have legacy debts? And if the answer is no, it's not in anyone's interest in trying to continue the business. Maybe we should be closing that business. Let's face it, all of us have clients who probably should be PAYG rather than business owners, and sometimes making those hard decisions is difficult. And I guess the final thing we do is, if we get referred a turnaround or work to helping a client, we make sure that the client's the accountant's fees are paid up front before we do any work.
Just a question. I had a couple of questions. First one is from Canyo, and in terms of property where you're securing a second mortgage, what's the general procedure dealing with the bank who might have a first mortgage?
Well, normally under any loan agreements, you're normally required to give notification of a bank before lodging a second mortgage. Saying that, lodging a second mortgage without consent doesn't make it invalid. We do lodge second mortgages for clients. We use legal parties. We have internal legal, but we do use external legal parties to lodge the documentation and do it properly. It can also sort of be used as to soak up equity in assets. As an example, if there's a DPN, a director's penalty notice against a director, or a personal guarantee from a trade creditor, if we can show that our client doesn't have any equity in that property, then certainly that creditor is more open to negotiating a settlement than they would be if there's significant equity in that property. So they can. It doesn't. A second mortgage does protect equity, and we can do that process. One thing I will say, though, there is two types of ownership. There's legal ownership and equitable interest. If the director with the guarantees on title, that doesn't prevent a caveat being lodged. Caveat itself, it doesn't force the sale of a property, but it does mean that the property can't be sold until that debt has been attended to. So without change of legal title, that can never be prevented if it's a charging clause in place. So we definitely, if there's a mortgage in place from the initial lender, we certainly can put second mortgages in place.
The other one was in relation to the PPSR we were talking about, the 20-day rule. How does that work with UPEs?
Yeah, that's a good question, that one. Look, it should be the date they're recognised. Yeah. Is a date of the 20 days ticks over. So obviously this is a little bit subjective, and I mean, with a director's loan, it's per se, it's quite easy. The day it's actually identified and money's loaned, it should be the date of recognition as a date we would consider as a date for the 20 days to kick off.
Perfect. And Michael, have you got we've got a few minutes left. Do you want to have a talk about the employee share plans?
Yeah, I will. So thanks, Grant. I won't bring up. I do have a full presentation. We'll do a separate deep dive into that at a webinar. But I have been working with about 4 LightYear Docs members at the moment in relation to employee share plans, and we will be launching documentation in relation to two different types of plans, one being a simple plan and the other being a complex plan involving an employee share trust. Just by way of background, before I got involved with yourself and LightYear, I was CFO, COO, and a listed company, or two listed companies, and I've implemented and administered employee share plans. At a listed company level, I've also put them at a private level. So I worked with Clutch, so Clayton Utz, tier 1 legal firm, and obviously we were doing an amount of work with Succession Plus, who is I guess would be seen to be a competitor, given we're going to have this service in the marketplace. And as you're aware, they did speak to yourself and myself, Grant, in Melbourne at one stage about us doing the back office and administration of those their share schemes and share plans. So we do have the product ready to go. I'm working with a couple of members. We'll do a webinar. I've got some great pictures and graphs and some details in relation to all those employee share plans. So I will be discussing it at our strategy breakfast tomorrow on the Gold Coast, and doing that presentation as part of that. So those attending will get, I guess, an early head start, but in the coming weeks, we'll do a presentation on it.
Perfect. Well, I'd like to thank Rod and also Michael for that great presentation. I've been around a long time. I don't think I've ever seen really to any great extent, a detailed presentation on PPSR, but it's absolutely crucial. I think it's something that is we're moving down the track before. And now after, once we get to the new LightYear Docs 2, and I certainly know I've been working pretty closely with Tim on a few interesting solutions, for example, being able to buy a property inside a family protection trust, and then having a long-term lease of that property outside to individuals, and still be able to claim the principal place of residence exemption. So we're working on that, and a couple of ones on those directors' loans as well, and securing that UPE, which is really, to me, there must be a lot of exposure out there. As Michael said, and I referred to earlier, we will be on the Gold Coast tomorrow, and it's a good 3-hour strategy session. Myself, Michael, and hopefully Rod will turn up as well and give his tuppence worth, and of course the inimitable Tim Munro. So it's going to be a great session. And watch out for our sessions next year, which will be in February and March. So looking very much forward to that. Anyway, I'll get this recording up and we'll flick it out to you a little bit later on today. And I'd like to again thank both Michael and also Rod as well.
Thanks, Grant.
Thanks, Grant.
Thanks, everyone.
Okay.
Thank you, guys.
Bye.